Thank you. Can I then just tell you briefly, before I finish, where we say that the judge went wrong, so as to be clear what our position is. I'm going to start on page 190, where the judge is setting out, it's paragraph 29.1, what his task is. And the first step he asks, to the extent those steps would include taking advice from an appropriate qualified advisor, what are the characteristics of that advisor, noting the characteristics might change over time. Now, if by that the judge means, what would the advisor's characteristics be in the sense of what views would he have from the past, and what background views would he have, then in my submission that's not the appropriate way of setting up the appropriate advisor. The characteristics of an appropriate advisor would be he would be a competent, qualified, good lawyer who was able, first of all, to grasp, as far as was necessary, the tax provisions that were in play, but more importantly, he was able to understand and advise on the European law position.
But hang on, I thought you were attempting to say, or otherwise, that the whole of 1 is just irrelevant.
It is, but I'm sorry, I'm engaging with the judge's approach and saying where, if you're going to take that approach, where he went wrong. I do say, I'm sorry, I could preface all this by saying this is the wrong approach to take.
So this is all the wrong approach, but if you're wrong about that, then the judge
exactly.
is wrong even
I'm
on that
addressing
approach.
the judge's...
Is that open to you on your grounds of appeal?
Well, yes, I think ground 2 is saying that the way that he dealt with the appropriate advisor was wrong. That was what we were saying. Which I think was, ground 1 is saying this is the wrong approach, and ground 2 is saying, well, if it's, rather the right approach, it's the wrong way of going about it, for various reasons. So we say that is all that you would want to assume an appropriate advisor had as characteristics, not that he brought any baggage into it by reason of history. And he would have available to him all the materials that were available at the time. That would be available and would be available to a court if the case was to go to court. And that's what we say is the significance of paragraph 178, if you remember, of the Supreme Court decision. Because anyone advising on litigation, I'm sure you've all done this, all you're interested in are, what are the materials that I can place before the court and are admissible and relevant to the decision the court's going to make. And taking account of materials that couldn't go before the court would obviously be a mistake in my submission. So straightforwardly, that's what the appropriate advisor would do, and that's just simply in place of what the judge would do, which is our primary case. So there's no real difference between the two, we would say. And then paragraph 32, we again disagree with what the judge says there. He says near the bottom of page 191, instead they would be guided by a high level appreciation of relevant legal principles in the expectation that if a worthwhile claim is indicated, there would be a more detailed analysis subsequently. Now, that might make some sense if you were adopting a very low bar at this stage.
You say you do have to adopt a very low
Well,
bar, as I understand it.
I do.
Non-strike outable, so what's wrong with it?
Well, if that were the approach the judge took, then that would be right. But that wasn't the approach my submission the judge took. He he didn't decide it on the basis of it's hopeless or it was struck out. He doesn't talk about that at all. He decides it on the basis of what the consensus view was of the law at the time. That's what he says he decides it on. So if you're going to do that, then you can't be in a position where you'll just be guided by high level appreciation, which is exactly what he does. In my submission, he looks at the high level points like what has been happening in the past in the EU, etc. But the difficulty with that is, the problem is that there will be no further analysis if you conclude there isn't a worthwhile claim. It's only if you conclude there is a worthwhile claim that there will be further analysis. So you can't use that as an excuse for not performing a proper job at this stage. And there's nothing in the Supreme Court judgment which suggests that the exercise that's carried out at this stage to decide whether there is something that would be worth investigating in relation to the mistake should be anything less than a proper analysis of the position.
What do you mean by a proper analysis of the position?
I mean by that, looking at what the actual principles that had been decided by the court and deducing from those whether there would be, whether the argument that there would be compatibility with the treaty was hopeless or was beyond that, was an argument that had some legs. That's what you would expect a competent lawyer to do in that circumstance. And to look at,
So you'd have to look at cases that were not directly on point, because there are no cases directly on point.
no, but you would have to look
at European case law.
Yes.
On what? Analogous situations?
You look at cases which had set out principles, and the main principle that I would suggest would be a guiding light to this is the principle which is established in Daily Mail and subsequent cases, that freedom of establishment can involve outward investment. So it's the freedom to establish in another member state. And you might ask the question, if that is the case, how can it be that European law would at the same time say that, but it also say resident and non-resident subsidiaries are not in a comparable position, and therefore there can never be a breach of freedom of establishment in relation to establishing a foreign subsidiary in relation to tax matters. You might ask that. Now, of course, the answer might be that is the position, but it doesn't seem intuitively like a very strong argument.
How many cases should the appropriate advisor have had in mind?
Well, only
Fiscal, Daily Mail, Schumacher, Commerce Bank. How many more?
And Avra Fiscals, obviously. So these are the only ones that there were up until the time we're talking about.
96.
On tax, which established, but they all established principles of general application. They weren't just on their facts, these cases. The point I'm not drawing from is not they're analogous in the facts, but that they established principles. And that what you would say at that stage is, looking at these principles, there is at least an arguable case here that there is a breach of the treaty. That's all you have to go. You don't have to say it's a good case or it will win or anything like that. But that's the exercise in my submission that you'd expect the judge in this case to have carried out.
The trouble is that the principles apply when you say there's a comparable situation, but if you don't get to the stage of finding a comparable situation, the principles don't apply, so it's putting the cart before the horse.
Well, no, because you then have to ask the question, well, why do you think they're not comparable? And there was nothing.
Well, that doesn't involve looking at the European case law, does it?
Well, what that involves saying is there may be an argument that they're not comparable, but there's no case law, there's no principles, there's no decision which says either way whether they're comparable. So if you're in that position, you're not going to say, well, they're definitely not comparable.
Well, wouldn't you actually be asking yourself if they are comparable?
Well, you might be. Yes, exactly.
There's no case law on that either.
There isn't any case law at that stage.
You'd have to come up with a reason for departing from what is said to be the consensus, which is that these are not comparable situations, before you even start putting your foot up the foothill at the bottom of the mountain, don't you?
Well, with great respect, my lady, I don't think that's the right starting point. And I don't think that's a starting point that any lawyer would take in advising a client on litigation. They wouldn't start by saying there is a consensus on this point, and therefore I'm going to have to find a way of shifting that consensus, because the consensus is only as good as the reasoning behind it, and the lawyer is able to deal with the reasoning in advising. So, I mean, maybe I'm on a limb here, but I don't think I've ever remember advising anyone on the basis of a consensus, and therefore you're going to win or you're not going to win a case. Because when you come to court, what would I say? I've based my advice on this consensus. Am I going to say to your lordships, there's a consensus? And you would say to me, well, so what? What are the reasons for that? What are your submissions in this case? I mean, nobody advising on litigation is going to base it on a consensus view in my submission. That's just not realistic to do that. Simply not realistic. And the problem that you run into with this is what the judge ran into. Because having concluded this, he then had to deal with the problem that people had brought claims in 2002. And so he was looking desperately for some reason to dismantle this consensus. Now, there was no evidence. Mr. Gammey's evidence was not that the consensus was dismantled, or whatever he was describing in 2000 by Verkuyen. In fact, he said Verkuyen, he suggested, didn't really have anything to say about it, or Hurst. What he said was, change the position, was Lenz, Mannon and Marks and Spencer's. So that's the problem the judge had. And the judge recognised that he couldn't say that was the point of discovery, because that would be after the claims were made. So he was in a bit of a problem then, having relied on the consensus position at stage one. He was kind of backed himself into a corner. And what he basically said in the end was, it was Verkuyen because Mr. Aronson conceded that position. That's essentially what he said. In paragraph 60, come to when he deals with, deals with Verkuyen. Paragraph 116. Yes, and yeah, 109. But just going back to the appropriate advisor, I mean, the second stage that the judge talks about is what would happen if an EU expert who wasn't in on the consensus were to advise. And his answer to that is, paragraph 87, that the EU advisor would have had to discuss the matter with the UK tax advisors, and that would have engaged the professional consensus, and that he would have accepted that consensus. Now, the difficulty with that is a question of EU law we're talking about, whether things are comparable. It's not a question of UK tax law, it's a question of EU law. So it's again wholly unrealistic to suggest that an EU law expert who hasn't got all the baggage of the UK tax professionals would come along and say, well, just if you say there's a consensus, fine. I'll say there's no claim. Paragraph 87. I mean, both of these would be, I would suggest, professionally negligent if they acted in the way that's suggested by the judge in giving advice. So it's just not a realistic approach in my submission that the judge has set up here. But then he comes on to the problem with when he deals with Verkuyen. If we have our submissions, I think we and the test claimants in relation to ACT both agree that Verkuyen doesn't have anything of importance to say. Certainly, if there is a consensus, it doesn't dismantle it. So the problem with the consensus position is that you get to the absurd conclusion that it didn't come to an end until 2 or 3 years after some of the claims were issued, and many of the claims were issued in this case. So that's the problem with the judgment in a nutshell, in my submission. What the judge ought to have done is look in the round in making his factual findings. If he was making factual findings, he ought to have looked at the position of RCU in the future and asked the question, well, why was it that claims were made in 2002? If we're saying that everyone was saying it was impossible earlier on, how can that be true if claims were made? Now the answer may be in one of what the judge says about the extent of Mr. Gami's evidence. This is paragraph 76, where he says, HMRC attaches significance to Mr. Gami's acceptance in cross-examination that it may be out there was somebody who thought otherwise. The consensus he put forward in his expert report, I do not consider it to be significant. Mr. Gami had the expertise to describe a consensus but could not reasonably confirm the views of everybody advising on the issue at the time. So maybe the explanation was that the people who advised the claimants to bring the claims in 2002 and 2003 were not part of the consensus. Because Mr. Gami accepts that not everybody was involved in it. But that just shows you the problem with this approach, this factual approach to the question. Because you end up with who's within this magic circle and who's not, and how many people have to be in it before it makes a difference, if it's supposed to make a difference. So we say the judgment is overall very unsatisfactory in all of these ways. It simply doesn't hang together in my submission. I think I've probably taken enough of Mr. Ernst's time. I'm sure he's desperate to get started, but unless there's any specific questions, those are my submissions.
Thank you, Mr. Yurt.
Good afternoon, my lady. Good afternoon, my lords. This is the third time we've been to the Court of Appeal in this case. It's actually the 8th time we've come to the Court of Appeal in this case and the related ACT, GLO, and related CFC and dividends, GLO. Extraordinary.
It's the gift that keeps on giving.
My wife doesn't see it that way, my lady, but yes. Without tempting fate, I would say and urge you to recognise that you have, by a country mile, the easiest task of any of the courts that have sat here in the Court of Appeal, in this case or related cases. And I say that for one very simple reason. You're here because the Supreme Court has told us, which includes you, what needs to be done, and it's been done. I'll take you to the passages soon, but I'm sure you remember them. They're in paragraph 178, 255 with a throwback to 176, discoverability in reality. Take you through the stages of what the Supreme Court has asked you to do. Of course, you're conscious of them, but just worth reminding ourselves of the words they've used, and probably better in your judgments with respect, stick to the words they've used rather than your own glosses, however tempting it is. But can I preface my remarks, which are going to be at a very high level of generality, because, as I say, everything's been done in this case already. But it's important to note one thing. I imagine, I suppose, you've read carefully the whole of the Supreme Court judgment and the whole of Mr. Justice Richard's judgment. You will have noticed in the Supreme Court judgment, he talks about this being the frontier of legal development involving colossal sums of money. The reason it involves colossal sums of money is that the taxpayers' claims in the FII case involve depriving the UK revenue of tax because tax has been paid overseas. It's something which is quite easy to lose sight of, but that's at the nub of this case. That's why this was an extraordinary leap from the earlier avoir fiscal days. It's a point that was picked up by Professor Snowden in that long article he wrote, which came to no conclusion, where he actually talks about recognising that if one were to take account of foreign tax, it would mean depriving the host state or the other state of its taxes. It's very different from Hurst. Hurst was merely a timing difference. ACT had to be paid. The question is, or corporation tax had to be paid. The question is when. Either when a dividend was declared through ACT, or I think it's 9 months at the end of the accounting period for mainstream corporation tax. An important point, but pretty a tiddler in this pond. This case raised enormous questions of the ability of a state to tax income coming into the state. So that's the background. And the issues that are involved in seeing whether there can be restitution of these payments involved dozens and dozens of fascinating legal issues, which we don't have to touch on now. That's what the courts have been involved with before. This is a very straightforward question. At what stage should it have been apparent to a well-advised claimant that it had a realistic chance of successfully arguing that it had paid the taxes by mistake? That's the question. There are 4 elements laid down by the Supreme Court in paragraph 178. The nature of the test, which I've just summarised as a realistic, a real possibility that there had been a payment by mistake. You have to seek the answer to that.
Those two aren't necessarily the same. A realistic chance of getting back the tax isn't necessarily the same thing as a real possibility that there's been a mistake.
Well, a real possibility that it shouldn't have been paid because it was contrary. It shouldn't have been demanded because it was contrary to EU law. That's the test. To what has the test to be applied? What's it got to be applied to? The Supreme Court, again, in the same paragraph 178, very specific. It's to the particular question whether the UK taxation rules governing dividends from overseas were compliant with EU law. That's the question. And now we come to the nub of this appeal. In what way has that to be applied? The answer to that is by reference to the development of legal thinking. And let me pause here and take up a point which I think my Lord Justice Snowden touched on. If we're dealing with questions of fact, the task of this court is simply to see whether the judge has come to a conclusion which was not borne, could not be borne out by the facts, or whether he's made some obvious error in applying the facts. And I've used the word facts and facts twice, because What the Supreme Court has done, whether we like it or not, is to try to equate the 32(1)(c) treatment of mistakes of law as near as can be to the treatment of mistakes of fact. And by asking the question factually, what was the development of legal thinking over the period that needs to be examined? That is a surrogate for a question of fact. It's approaching it as if that were the fact that needs to be discovered. And in that way, you end up with a sort of equation. You don't in the case of fraud because of the higher threshold for fraud, but you do in other cases. It's just a thought I've had as to why do they put it that way. But anyway, whatever the reason, that's just my own view of what they were doing. So I was there wondering what they were doing. I can see the logic in doing that, trying to achieve consistency. But it becomes a question of fact. What was the development of legal thinking? And then we come to the fourth element. How is that to be determined? The answer is, using their own words, by evidence. What evidence? Evidence of what practitioners thought, universities thought, commentators thought, judges thought. Now, without wanting to be facetious, if your lordships were to have a petri dish and add to a few human stem cells the DNA of a practitioner, of a university professor, of a commentator, and a judge. We keep it at 37 degrees, I think with 5% carbon dioxide, so ChatGPT tells me, if you want to create artificial tissue, you will end up with Mr. Malcolm Gammy, who is all four of those. Not only a practitioner both sides of our legal divide, specialising in corporate taxation, sub-specialising in cross-border corporate taxation, appointed the Unilever Professor of Law at Leiden University, 1998. Look what's going on with Verkoyen at that time. Leiden University, for the specific purpose of considering the taxability of cross-border flows. It's a commentator with his colleague, Mr. Brannan. He wrote the article, I can't remember when it was, 1996, 7, something like that. And he's a judge, as we saw in the Marks and Spencer case, to my chagrin at the time. I must say, I found it very frustrating. He had that mindset, one might say, the consensus view that the situations were not comparable. It's only when we went to the ECJ that we managed to persuade them they were, even though they came up with some other twirls relating to justification, which weren't entirely to our liking. But anyway, there we were. But we can go further than that. What other judges are there? Now this raises an interesting question of hindsight. But how about the justices of the Court of Justice of the European Union? They're there. And what do they say? It's only with the judgments in Verkoyen, Lentz and Manningen that one can begin to see the development of the principles that apply. Everyone is saying the same thing. Now, my learned friend very helpfully has made a pretty significant error in what he was saying, and I'll point to it. It's helpful because it saves a lot of time. But let's accept the evidence was there was a consensus view, probably based on non-comparability, taking into account the loss of tax that would be involved to any given state if one were to give credit for overseas tax, which hadn't been mandated by a double tax treaty or a directive. But let's go through the 90s and see what material there was. You start in 1990 with the Parent Subsidiary Directive. I don't know whether you've looked at it. The preamble goes on about creating a wonderful world in Europe and sort of free integrated market and all the rest. It just lays down a very simple principle that where one is taxing foreign dividends, you either have to exempt them, if you exempt them domestically, or give credit. That's all it says. I don't know whether you've seen it. I can take you to it. Probably worth doing. But let me run through the other ones as well. There'll only be 4 things I'll ask you to look at. So that's the Parent Subsidiary Directive. You then have the Ruding Committee. The Ruding Committee was a committee of 13 experts appointed by the European Commission precisely to address the question of the problems arising with cross-border flows in business. The detrimental effect on business of having differential tax systems. The report in the printed version, which I read at some stage long ago, is 470 pages long. There is not one mention of the possibility that the treaty freedoms solve the problem for them. Not one. Nothing, not a hint. And yet, their terms of reference was to consider every means by which one can reduce the frictions, to use the economist's term, the frictions involved in cross-border flows. Then we come to 1992. Then we come to 1994, and we have Farmer and Lyle. Now, my learned friend cross-examined Mr. Gammy on one particular page of Farmer and Lyle, saying this page here is really dealing with the situation where dividends are paid out to the parent company, not received. And therefore you can't extrapolate from that any general principle that should be left to the competence of the states. What my learned friend didn't do, very conveniently for us, is he didn't turn the page. So if you turn the page, you find that what Farmer and Lyle say on this is that in dealing with incoming dividends, it may well be that the Parent Subsidiary Directive went further than treaty law requires. I'll take you to it shortly. But let me preface my taking you to that by just mentioning who they are and what this book was. This was the main book on European law as applied to taxation. Mr. Farmer at that time, although he looks like everyone's favourite uncle sitting behind now, was the referendar of Sir Francis Jacob, who was the Advocate General at that time. He went on to become the head of direct tax at the Commission. Jacobs, I do apologise, of course, Jacobs. And he went on.
I only say that because he taught me at King's.
Oh, right, well. And I'm sure he had a fair share in the writing of his own judgments, or his own opinions,
yes,
with Mr. Farmer.
No doubt about that.
And who was Mr. Richard Lyle? Well, he was in the legal service of the Commission. These were two very highly qualified, almost uniquely qualified team, writing the main textbook published by Oxford University on EC law and taxation. And that takes us to 1994. Nothing really happened after that, apart from Schumacher, which said, as a general rule, the position of residents and non-residents are not comparable. There was an exception in that case because all the income was earned in Germany, I think it was, rather than Holland. Fine. 1998, the Gilly case, which confirmed that disparities in taxation that arise from each competent state's ability to impose its own taxes are not something which the treaty normally deals with. Something which Professor Tiley at the time, writing in the All England Review, said breathed a sigh of relief because otherwise there might have to be intervention by states withdrawing tax from the competence of the European Union. So there we are. Can I take you very briefly to all the passages I've referred you to? It shouldn't take more than about 15 minutes, so at least to make good the propositions that I've done. And then I'll just deal with a few other points which my learned friend has made before turning to the FCE appeal. I don't know whether, my lady and my lords, you actually want me to turn to paragraph 178. I imagine you have it pretty firmly in your minds, but maybe it's no harm just looking at it again, just to see that I have paraphrased it, if I'm paraphrasing it at least correctly. Okay, so 178. Can I just take it? Probably tedious listening to someone reading when you can read it perfectly well yourselves, but if we take it bang in the middle, beginning secondly, thinking about the law evolves over time. Developments in judicial thinking in particular do not take place in a vacuum. Judgments are the culmination of an evolution of opinion within a wider legal community, to which practitioners, universities, legal journals, and the judiciary all contribute. And it's not only judges who are influenced by that evolving body of opinion. Claimants and their advisors respond to the same developments in their understanding of the state of the law and their decisions as to whether or not worthwhile claims may exist. It's therefore possible to investigate how legal thinking on a particular question, for example in the present case whether the UK tax treatment of dividends received by UK resident companies from non-resident subsidiaries was compatible with EU law, developed over time, and to ascertain by means of evidence the time by which a reasonably diligent person in the position of the claimant, such as in the present case a UK-based multinational company, could have known of a previous mistake of law to the extent of knowing that there was a real possibility that such a mistake had been made and that a worthwhile claim could therefore be made on that basis. So all four elements are just captured in that one paragraph. And then that throwback to 176, the sentence, it must therefore be concerned with discoverability in reality. So that is, I say, is a surrogate quasi issue of fact which this court should not disturb unless the judge has made an obvious error or unless there was no evidence upon which the judge could reach his conclusion. Not only is there no that could not be made out, the opposite is true. There was abundant evidence and he made the right conclusion. The directive is an authorities bundle at tab 8. I don't know whether your numbering of the bundles is the same. This is my bundle 1. Very brief passages only. The preambles to treaties are always flowery, and this one is a full vase. It's at page 114. Has your ladyship found it yet?
No, not yet. I'm
Okay.
sorry, my...
No, don't worry. I think we're well ahead of schedule. I can put it that way.
Obviously. So it's not that. It's volume 1 of the authorities bundle, isn't it?
Yes, it's volume 1, at tab 8 if you have tabs, at page 114.
Where my volume 1 has gone to. Oh! No, that's volume 6. Here it is. Right in front of my eyes. Sorry, Mr. Anderson. Tab 8.
Yeah.
Yes.
Your ladyship would just like to read the first long preamble. You'll see the third preamble.
Yeah.
Whereas the existing tax provisions which govern the relations between parent companies and subsidiaries of different member states vary appreciably from one member state to another and are generally less advantageous than those applicable to parent companies and subsidiaries of the same member state, whereas cooperation between companies of different member states is thereby disadvantaged in comparison with cooperation between companies of the same member state, whereas it's necessary to eliminate this disadvantage by the introduction of a common system in order to facilitate the grouping together of companies. The very issue of discrimination, the subject matter of this directive, and then if you just go over to the right-hand side, they've adopted this directive. Article 1, each member state shall apply this directive to distributions of profits received by companies of that state which come from their subsidiaries of other member states. I mean, to say that the consensus was baseless is extraordinary. It's telling you, the directive is telling you how you deal with these disparities, disadvantages. Then Article 4, subparagraph 1, this is at page 115, where a parent company, by virtue of its association with its subsidiary, receives distributed profits, the state of the parent company shall, except where the latter is liquidated, either refrain from taxing such profits, that's the exemption method, or tax such profits while authorising the parent company to deduct from the amount of tax due that fraction of the corporation tax paid by the subsidiary which relates to those profits. And if appropriate, withholding tax. That was the UK system.
Now that was entirely compatible with the directive.
Absolutely. Absolutely. So 1990, no issue at all. The UK was fully complying with the directive. It didn't have to change its rules. Those were the rules. I don't think we need read anything else in the directive. It's not that there is very much more to read anyway, if we wanted to. And then one moves on to the Rudy thing. Now, we don't have all 470 pages. We don't even have the front page saying who are the members of the ruling committee, but there were various luminaries, including ex-finance ministers, professors, and so on. It was the committee of experts. This is at tab 24 of the supplementary bundle. see at page 247, the front cover, which, like so many other front covers, uses an awful lot of ink off the printer for no purpose whatever. It's the report of the Committee of Independent Experts on Company Taxation, and it's a European Commission report. If one turns over to page 249, well, if we look at 248, it's got the contents page. It tells you, page 7, who the committee are. We don't have that printed. The committee's mandate, we do, the executive summary, then the glossary of terms, the introduction, tax problems in a single European market, the taxation of business income in the European community and its main trading partners, the pattern of tax distortions to investment, the effects of taxation on international investment, international tax planning and its limits, tax competition, tax coordination, tax harmonisation, some theoretical and empirical observations. Have European community corporate taxes converged in the 1980s? Corporate tax harmonisation and competition for non-EC federal companies, conclusions and recommendations. So it's covering the whole gamut of issues that arise in cross-border taxation. The mandate is at page 249. The committee will evaluate first and foremost the importance of taxation for business decisions with respect to the location of investment and the international allocation of profits between enterprises. An assessment of the impact of taxation relative to other factors on such decisions is necessary in order to determine whether existing differences in corporate taxation and the burden of business taxes among member countries lead to major distortions affecting the functioning of the internal market. If such distortions do arise, it is essential to examine all possible remedial measures, taking into account the influence that other policies, the economic and monetary union might have on the extent of the tax-induced distortions. Don't go any further. But the mandate is examine the entire gamut of cross-border taxation to see what impact it's having on friction within the single market, and to examine all possible remedial measures. If there had been one clause, even one word, relating to the treaty freedoms in the 470-something pages, HMRC, with its ample team, would have found it. Not one word. It's all to do with community measures, directives, and so on. It's no answer to say, well, they were thinking in terms of community-wide measures. But if they were, that's because they assumed they'd had to be community-wide measures. So that's the directive. 1992, it was published. The findings. And then in the same volume, Farmer and Lyle work on, I think it's taxation in the EC. The title page of the book is only in the index. Is it, well, it's at tab 27. Tab 27 says, Farmer and Lyle, EC Tax Law, Clarendon Press, Oxford. This is chapter 16. There was one other textbook, but these were books written by people at the coalface, one at the Court of Justice, one at the Commission. It was a very authoritative book. It was the only real work that people would turn to if you wanted to look at a textbook written by people who were intimately knowledgeable, closely knowledgeable of everything relating to the taxation and EC law. The chapter begins on page 263 in the bundle. The prohibition of discrimination and the fundamental freedoms, their impact in the sphere of direct taxation. You couldn't have a more specific chapter title. So if you wondered, if you were to Google, what's the prohibition of discrimination and fundamental freedoms? Is there any impact on fundamental freedoms in the sphere of direct taxation? You would have been directed to chapter 16 of this book. The passage that my learned friend cross-examined Mr. Gammy about, if I remember rightly, quite towards the end of the cross-examination, taking Mr. Gammy just specifically to this passage, is at the foot of page 269 of the bundle. The principle of non-discrimination on which the judgment and commission in France is based doesn't oblige a member state to take account of the fact that a non-resident company may be subject to further taxation on certain income in its state of residence or elsewhere. Double taxation arising from conflicts of tax jurisdiction must be resolved by convention or harmonisation. Now, the judge took that to be a general statement, whether one's looking at inward investment or outward investment, whether one's looking at the UK company with a foreign parent or the UK company with a foreign subsidiary. My learned friend said that's wrong. It's purely looking at the UK company with a foreign parent. It doesn't say so in terms, but even if that were right, it makes no difference because turn over the page. Relationship between Article 52 and community legislation on company taxation. From the above discussion, it also follows that the relief from withholding tax which member states are required to grant under the Parent Subsidiary Directive, I didn't take you to that one clause because we're not dealing with withholding taxes, in respect to profit distributions made by subsidiaries to non-resident parent companies is probably not required by Article 52 itself. Withholding taxes generally represent only partial taxation of the dividend income of non-residents. Similarly, the tax relief granted by the directive to parent companies in respect of distributions of profits received from their subsidiaries in other member states goes further than Article 52 by requiring the member state of the parent company to take account of tax paid in another member state. So I'm grateful to my learned friend for not turning the page. But there you have it. That was the thinking in the leading textbook on EC law and direct taxation, dealing specifically with the issue of income received by UK companies, or by a company in a member state from a subsidiary in another member state. So to say, as my learned friend's case does, I'm not entirely sure whether this is his main case, whether his main case is the Supreme Court test is unworkable, but to say that the consensus described by Mr. Gamby was not based on anything apart from people just not thinking of it is nonsensical. It was based on a clear understanding that the sort of disparities arising from overseas taxation, insofar as they were not dealt with by the directive, could not be dealt with by the treaty freedoms. And that held good. The reason, as a matter of analysis, probably because of non-comparability of the situations, if you need to start putting labels on the analysis, that held good through Gillian in 1998, I think Gillian was, until Vacoyan. When even though we were talking about a fairly piddling amount of tax relief, I think was it 2,000 guilders, 1,000 guilders? I'm not entirely sure what it was. 1,000.
I think
even
it was
though
2,000 because he was married.
2,000, all of 2,000 guilders as an incentive to invest in Dutch companies rather than non-Dutch companies, which was what the complaint was. I work in Belgium, this is my employer, I've got shares there, it's not fair I'm not getting this as an exemption. In the course of the argument, whether it was in the unpronounceable Dutch Supreme Court, whether it was in the first of the AG's opinion, whether in the second of the AG's opinion, that was the thrust of the reason Mr. Flocarian won. Mr. Gammy was there. I don't know how far Leiden is from wherever Mr. Verkooyen's lawyers were, etc. But I imagine the case had been mentioned. I mean, it was a Dutch case after all. He was dealing with all that. It didn't seem to matter. But when you think about it, hang on, we've got a foreign dividend, and yet the state receiving it has got to give credit, even though it's a very small amount, for foreign tax. I think, if I remember rightly, in the judgment of the ECJ, where they were saying, but hang on, isn't this depriving one state of the right to tax? They said it's a rather small amount. I think they used those words or paraphrase like that. But that was the beginning of the question mark. Hang on a second. Are you saying the treaty freedoms actually do apply to dividends from overseas? That's interesting. Mists, I mean, it's not for me, who's probably used more poor metaphors in my career than the rest of this courtroom put together. It's not to be criticised that. But okay, the mist's beginning to go, raises the question. Now, what has amounted there? Is there an arguable case for saying the UK's system, which complies wholly with the Parent Subsidiary Directive, is non-compliant with the freedom of establishment? Answer is, I can see why you're asking the question, but no, they're not in a comparable situation. That was the learning of that time. And that takes us way beyond 1996, which was their cut-off date, way beyond 86, which was the avoir fiscal, 1973, when we joined the market, all the things that Professor Barnard thought ought to have made the penny drop, all the times. It takes us up to 2000. And I repeat the words, it's in the Supreme Court judgment, I think paragraph 24 or 25, they actually set out what the ECJ said about the development of legal thinking in this area. It's only with the judgments in Verkooyen, Lentz and Mannanen that the principles relating to what we're dealing with began to become clarified. The judgment in Verkooyen was a sort of wake-up call, not a very loud one. I did mention Professor Lodin, and I said that in his inconsequential but very interesting nonetheless, we have the time to read it, article, he notes the issues that arise when you're calling on a state to give up its taxing rights. That is at tab 29 of the same bundle. I know I'm filleting this, but I mean, frankly, we'll be here all night if we're going to read the whole thing. But if we go to page 303, the right-hand column, and it's the first complete paragraph on the right. Whether or not the problems caused by the imputation system will be brought before the ECJ, or whether or not the imputation systems will be found to obstruct the goals of the EU, the practical effects are reason enough for demanding reforms. Although already the Reading Committee criticised the existing imputation systems for discriminating against dividends from profits earned in another member state and urged that this discrimination be removed. The question then is how this should be achieved technically. In their imputation systems, France and the UK give foreign shareholders a relief fully or partially equivalent to the credit received by domestic shareholders on their dividends, i.e. the country of the distributing company, the source company, gives the relief. In that way, capital import neutrality is achieved. However, there are several reasons why this is not the ideal solution to the problems. First of all, it would effectively mean that the source country would give up its tax base and its rights to tax profits on operations carried out by companies to the extent that they were owned by foreign investors. It would not be appropriate to force any country to such dramatic reductions of their tax base. Moreover, the method doesn't solve the problem of different treatment of domestic and foreign dividends in the state of the shareholder. This means that the question of capital export neutrality, which is crucial in relation to the principle of free movement of capital, will not be solved. It's a very learned article saying these are serious problems. You're expecting companies to give up their tax base. You can't do that, and yet you've got to do it. You can't do it, but you've got to do it.
There's a reference there to the Rudin Committee and a criticism that it made. Is that relevant, or do we have it? Well, I suppose two questions. First of all, is it relevant? I thought you said there was just nothing in that.
But it criticised the existing imputation system for discriminating. We know it discriminates against it. There's no doubt about that.
No.
But they don't.
You showed us the committee report simply for the purpose of saying there's nothing in it.
There's nothing in it relating to the treaty freedoms. They're asked to look at every possible way of dealing with these frictions, these disparities, these extra tax burdens. But the one thing they don't do is say, well, actually, there's Article 52, or there's the other one. That's the only point.
Well, in a sense, your point is made made stronger if they identified a problem and didn't say it's solved by the treaty. Isn't it?
No, they don't. They don't say it's solved. They just said they don't consider whether the treaty was not thought to have any impact on this situation.
That's the point. But if they just completely missed the problem and therefore didn't mention it, then okay.
Yes.
Which I thought is what you'd. And
that is right. It's not that they missed the. They knew the problem was that there was extra burdens of tax. Everyone knew that. I mean, the ACT Sufferers Club and all the rest of it's been around since the 80s. Everyone knew.
It's after lunch and I may be being a bit slow. I'll be corrected if I am. I think I may be trying to make a point to help you here rather than not. So just be careful not to push back too strongly. Either that, or I've just misunderstood what you're saying. In which case you can push back as hard as you like.
No, I'm leaning back because I'm not pushing back.
Okay. When I was listening to you talking about the Rudin Committee, I thought you essentially said there's just nothing in here. If there was some problem or something else, they would have said something about it. But what this appears to suggest is they did identify at least some problem in the general area, but didn't identify any solution already existed.
Exactly.
And I was just asking, where, just out of interest, do we actually see where they identified the problem?
We sort of in some of the Supreme Court actually comments on it. I'm told that the Supreme Court comments on it in 34. I'm sorry if this appears to be a pushback. I'm always delighted to get a following wind. But in this particular case, the Rudin Committee was well aware of issues that arose. They discussed them over 470 pages.
Right.
But there isn't one mention of the fact that, by the way, this is all dealt with by freedom of establishment or freedom of movement of capital and payments.
So that point I got.
And that is the only point I'm seeking to make of it. And a committee of experts, almost by definition, ought to be sufficiently expert to know, especially as it includes, I think, the ex-finance minister of France, I may get this wrong, who would have been well aware of avoir fiscal and all the rest of it, would have known that there is such a thing as Article 52.
So they've identified that it's not only arguable, but probably unassailable that there is discrimination. Looking at this passage in the Swedish professor's report. But they haven't turned their mind to the fact that the discrimination could be said to infringe Article 52.
Exactly.
Okay, that's
Exactly what it is.
My lady's already
So-
had
so
a better lunch.
If my
than
lord
I
was
did,
saying the
so-
same thing, I entirely agree
Or
with that.
less good lunch.
Well, I don't. Pret doesn't give you that much. Okay, so anyway, but it. Right. Well, you haven't. Okay, we don't have a reference in the bundle to the relevant.
I'm afraid not.
bit.
No. I mean, it's just not. It's a massive tome. But all I'm saying is, my learned friend said, "Aha! There was an article pointing Professor Lode in 1998, which is before 2000, before Vacayan." Doesn't he just? It's a general discussion of the issues that arise, and he doesn't come to any particular conclusion, and that's exactly what Mr. Gammy said. It was a sort of a muted conclusion.
So they basically put their finger on the fact that it's potentially discriminatory, but nobody's actually put two and two together and said the discrimination which we have identified is potentially in breach of the freedom of establishment or the freedom of capital, etc.
Yeah. If any of the 13 experts had gone to Professor Barnard, she might have said, well, from 1973 or whenever the European coal and steel community was set up, I think is when she would actually have the starting point. It was all implicit. But they didn't think it appropriate to think like they didn't think like that.
As you mentioned, the Supreme Court does summarise the position in paragraph 34 of SC2,
Yes.
referring to the Ruling Committee and to the Loden article. Just prompts the question why they didn't think they had enough material on the basis of that to come to a decision themselves.
My lord, if your lordship finds yourself sitting in a lounge suit in the Supreme Court building, you might think differently. It's rather nice to be able to give the task to someone else.
Yes, I see.
They've already heard 2 lots of long appeals, and remember this was a serious case, considering whether DMG applied and whether Klein-Walk-Benson should be overturned.
So they wanted to decide the question of principle,
They wanted
push off the detailed application to somebody else.
If the parties can't agree, is what they said. I think they said the parties can't agree, it should be decided by remitted or whatever.
I mean, paragraph 34 of the Supreme Court judgment is worth looking at, isn't it? In light, I mean,
Yes.
following on from what my lord has just said. If they thought that was an answer to their test, the test that they postulated later, it's slightly surprising they didn't say so.
Well, except that might not be the sole, they might not have thought that they had all of the material, but just some of it. As Mr. Ewart has very fairly pointed out, all of the authorities were not before the Supreme Court. And so what you've got at the moment is just the directive, and you've got the I don't know how much of Ruding they had, but Ruding and keep forgetting his name. Loden.
This is sufficient to see this breach.
Yeah. While we have this page open, it might be worth just turning back to paragraph 24, though that was dealing with the Frankovich factor claim type claims.
Yeah.
But it's worth seeing. In a field such as direct taxation, the consequences arising from the freedoms of movement guaranteed by the treaty have been only gradually made clear, in particular by the principles identified by the Court of Justice since delivering judgment in the Commission of European Communities and French Republic. Moreover, as regards the taxation of dividends received by resident companies from non-resident companies, it was only in Vacayan, Lentz and Manningham that the Court of Justice had the opportunity to clarify the requirements arising from the freedoms of movement, in particular as regards the free movement of capital. And they quote para 216, apart from cases to which directive, parent subsidiary directive applied, Community law gave no precise definition of the duty of a member state to ensure that as regards mechanisms for the prevention or mitigation of the imposition of a series of charges to tax or economic double taxation, dividends paid to residents by resident companies and those paid by non-resident companies were treated in the same way. It follows that until delivery of the judgments in Verkeyen, Lentz and Manning cases, the issue raised by the order for reference in the present case had not yet been addressed as such in the case law of the Court of Justice.
It's not necessarily the same question, because the Frankovich question is whether it's a manifest breach, effectively.
No, it's not the same question, my lord, I entirely agree, but why would the answer not be equally applicable?
Yes. Well, because it might be a different test.
Well, it's not a test, they're just saying whether it began to be clarified. Either it began to be clarified or it didn't become to be clarified. I don't want to mix mists and mountains and clarifications, but that's what the ECJ thought, the judges.
Yep.
And it's what Mr. Gami said the profession thought. So those are my main submissions on the on HMRC's appeal, but can I just deal with a few odd points which my learned friend brought up, inconsequential they may be. In Hurst, he said at one point it was difficult to know why the claimants regarded the treaty credit claim, which I think was question 3, as depending on the answer to question 1, which was whether there was whether the group income election should be allowed. He couldn't. He said didn't seem to be any reason. It was just done. Of course, there was a reason. The reason was simply this: that ACT was the prepayment of the tax credit. If you didn't pay ACT because of a group income election, which is what they were asking for, the German company couldn't get the tax credit. So if you won on the first point, the other one just didn't arise. At that stage, in ACT class 4, they had a punt at saying, well, hang on a sec, and in Pirelli, which was ACT class 2, hang on a sec, maybe we can get it both ways. And in Pirelli, we did until we got to the House of Lords, very annoying. We actually had it both ways. We won in the High Court, we won in the Court of Appeal. And then in the House of Lords, they say, don't be ridiculous. ACT is the prepayment of the credit. You don't pay ACT, you don't get a credit. Make your mind up. Do you want your ACT or do you want the credit? It's up to you to make the choice. So that was the decision we got. That becomes relevant when I turn to FCE cross appeal. Because there, although I'm saying that you've got a very easy task as far as the main appeal is concerned, cross appeal, you've actually got an easy task for a totally different reason. The judge identifies the reason. He dismissed our case on that, and he was wrong. It's very clear why he's wrong. I can show you that. It's a very narrow point. Anyway, that's the first point of clarification. Second point, when did the companies first in fact start the process of questioning the legality? My learned friends somehow thought that advisors would keep this secret under wraps. I doubt whether he thought they were going to be put in a deep freeze. We know that the first claim was made by, I forget its company. Who was it? Yes, Evonik in 1992. We know that was after Verkeyen, we know it was after Hurst.
You said 1992.
2002, sorry, yes, 2002. And Mr. Cohn, and so I think it's paragraph 34 in the Supreme Court judgment, is recorded as saying it was with Verkeyen that they raised the question internally, whether there might be. Whether there might be, one might ask whether the D5 charge and the others were contrary to European law. My learned friend said that, and funnily enough, this is actually part of their case below as well, advisors might keep these clever points under wraps. I mean, that is patently absurd, but even if it weren't absurd in the abstract, it is in the present case because of the ACT Sufferers Club. Now, I don't know, you remember that's referred to in Mr. Justice Richards' judgment? I'll take you to it. I can remember where it is. In the 1980s, the companies, many of whom groups, part of this GA, formed an ACT Sufferers Club, as they called it, and they would lobby year after year the Treasury, please sort this out. We are paying ACT, which we can't set off against corporation tax.
This is the surplus ACT.
Surplus ATC. It's the judgment, paragraph 53. This was a lobbying body, very vocal, very powerful. If any advisor, any of the big four, or in those days it was probably the big five or the big six or the big seven or whatever, but if any of the big accounting firms had a clever argument for saying that you shouldn't have to pay this ACT, you can bet your bottom dollar, as the Americans would have said, that would have been brought to the attention of the members of the ACT Sufferers Club. Too obvious. So, those are my submissions by way of summary. My learned friend, who can deal with all the detailed arguments raised by my friend when he follows me. But I'm not going to go into any further detail unless you wish me to. But can I now turn to the FCE cross appeal? And for this, we need to turn to paragraph 138 of the learned judges. Otherwise, I may say so without wishing to sound patronising or facetious, first-class judgment.
Sorry, could you give the paragraph number again?
Yes, well, the relevant passage, or section of his judgment begins at page 521, which is paragraph 130, the period after 6 June 2000, constructive discovery in relation to the ACT charge. You remember FCE 4, as we call it, was only challenging the ACT provisions, and they raised their claim in 2009, so they had to get to 2003 to be within the limitation period.
2007 and 2009.
Oh, so sorry, 2007. EMI was 2009. 2007. They've got to get to 2001. So 130 says, thus far I've concluded the date of constructive discovery in relation to D5 was the 6th of June 2000. Therefore, the final issue that I need to determine is the date of constructive discovery in relation to the ACT challenge. The claimants put their case on this issue in the following way. Their primary case, as advanced in their closing submissions, was that the date of constructive discovery as regards an ACT challenge was September 2004, the date on which the CJEU gave judgment in Manila. Conscious of a difficulty with this argument, namely that the averred date of constructive discovery took place after Evonik had actually made an ACT challenge on the 11th of July 2002, the claimant's first fallback position was that constructive discovery took place only on 6 November 2003, the date of the publication of FIIGLO, on the basis that only then could a well-advised multinational have known that Evonik had brought an ACT challenge. As a further fallback, and this is what we're dealing with now, the claimants argued that constructive discovery of an ACT challenge could not have taken place earlier than 8th of March 2001, the date on which the CJEU gave judgment in Höchst. The justification for that position was that only in Höchst was an essential building block of an ACT challenge established, namely that ACT should be regarded as a prepayment of corporation tax and so is equivalent to foreign corporation tax. My lady, my lords, that was our submission, and that is our submission, and that submission, in our respectful submission, is correct. And I'll explain why. Now, how does the learned judge deal with that? Well, very helpfully, he says that paragraph 138, there are two flaws in that argument. The first is that it was not the CJEU in Hurst that decided that ACT was in the nature of corporation tax. That was a conclusion on the meaning of UK statute law, which Mr. Justice Neuberger determined in a judgment given on 2nd October 1998 and proceeding second in the terms of the order for reference to the CJEU in Hurst. Mr. Justice Neuberger determined in his judgment that the matter was put beyond doubt by section 14.1 of the Income and Corporation Taxes Act 1988, which, as in force at the relevant time, provided that subject to section 247, where a company resident in the United Kingdom makes a qualifying distribution, it should be liable to pay an amount of corporation tax, advanced corporation tax, in inverted commas, in accordance with subsection 3 below. The second flaw in the argument flows from first. Well, if there's no flaw in the first, which I'll show you there is no flaw, then nothing flows from it. The claimant's argument is, on closer inspection, an assertion that before the CJEU's judgment in Hurst, a well-advised multinational would not have realised the significance that the CJEU would give to ACT's status as corporation tax. That is little more than an assertion that a well-advised multinational on 6th of June 2000 wouldn't have been able to foresee the precise basis on which the CJEU would ultimately determine the ACT challenge in the claimant's favour. However, the test for the discovery of a mistake under 32(1)(c) doesn't require potential claimants to foresee in advance all the ways in which a court might ultimately determine a claim in their favour. Rather, as I've explained in 21(4)(a) above, a relevant aspect of the inquiry is when, having exercised reasonable diligence, a well-advised multinational would have had sufficient confidence to justify embarking on the preliminaries to the issue of proceedings, such as submitting a claim to HMRC, taking advice, collecting evidence. It's quite possible for that threshold to be crossed without foresight of the precise way in which the claim will succeed. And then drop down to 141. Overall, therefore, I've concluded that the professional consensus on which the claimant successfully relied prior to 6 June did not survive the judgment of CJEU in Verkooyen. I see no other secure basis in the evidence for a conclusion that constructive discovery in relation to the ACT challenge was postponed beyond 6 June 2000. The date of constructive discovery in relation to the ACT challenge was accordingly 6 June 2000, the same date as the date of constructive discovery for a D5 challenge. Now, there was no flaw in our argument. Of course it's true, it wasn't actually in Hurst, it was in Metallgesellschaft. I know it sounds nitpicking, but I was the advocate in Hurst. And Mr. Gardner raised the question as to what was ACT in Metallgesellschaft. I didn't raise it at all, and the judge says, we'll look at section 14, it's corporation tax. Nothing more, nothing less. But it wasn't ordinary corporation tax to the mind of any well-advised or knowledgeable UK tax payer or tax expert. It was a subspecies that funded the credit. It was not corporation tax on profits. Now, I'm making that assertion on the basis that it's actually pretty obvious. But if you need authority for that, as my learned friend knows, because he was against me in this case, in that case as well, the issue arose in what was called Class 3 of the ACT challenge, which very confusingly is reported in the High Court under the name of NEC Computers, if I remember rightly. Semiconductors. NEC Semiconductors. And in the House of Lords, there's Boak Allen. Both of those authorities are in authorities bundle, and they're at tabs 24 and 29. But let me just explain, before taking you to the passages, why it arose in that case. That was the case not under European law, but under double tax treaties. We were saying, well, there's discrimination under double tax treaties. Say the German recipient of a dividend, it doesn't get a tax credit. And we said, well, why not? ACT is just corporation tax. It's liable to corporation tax in its own state, and so on and so forth. Or maybe no, it's the other way around. Was this a dividend? I can't remember. It was dividend received by or going up. It makes no real difference. Mr. Justice Park heard this at first instance. I don't know if you recall Mr. Justice Park before he became Mr. Justice Park, but he was the doyen of the tax bar at that time. And, we grew up together, enormous respect. We said that ACT is corporation tax, and the double tax treaty says that there should be no discrimination on the basis of place of registration or residence for corporation tax or income tax on profits and gains. We said there is discrimination because ACT is having to be paid, whereas were the parent to be a UK parent, it wouldn't have to be paid. The answer, Mr. Justice Park, was you can't be serious. ACT is not corporation tax on profits. ACT is a particular charge that is distinct from corporation tax on profits. So we lost. It wasn't covered by the treaty. Discrimination, yes, not covered by the treaty because it wasn't corporation tax on profits.
And you say, what, that point, that ACT is not mainstream corporation tax in advance, it wasn't apparent until the decision of the ECJ in Hurst.
I wouldn't put it that way, my lord, and I'm not sure your lordship would put it that way either, if
No.
I can put it.
Right again.
I can say,
Tell me what I ought to think.
yes. What I think your lordship is saying is the distinction between ACT as a separate subclass of corporation tax and not a tax on profits was not merely something of which the ECJ did not take account of, but they contradicted it because it was in Hurst, and that's why it was a bombshell in Hurst. They said ACT is merely corporation tax, and therefore it's corporation tax. You've got to treat it as corporation tax in the UK.
But, sorry, am I missing the point? You say that was a bombshell in Hurst. Why wasn't it a bombshell when the Advocate General said that?
Very good question. To which the answer is because it was such an absurd proposition that no one would take that seriously until we got the actual judgment. It was
So when at page 2053 of the Authorities Bundle, the Advocate General says in 2000, which isn't good enough for you, 12th of September 2000, which isn't good enough for you, it is clear that advance corporation tax is nothing other than an advance payment of mainstream corporation tax. Everybody said, "Coo, what a bombshell," but he's just...
no, they didn't. They would have said, well, that would be a
no.
bombshell if that were upheld.
So they just said,
by the ECJ.
They just said he's only the Advocate General, he's barking mad, so...
They're not
just didn't
barking mad.
ignore it.
You can't take that out. Surely he can't mean that. Let's see what the ECJ says. And it was the decision, the judgment in Hurst that was treated as the bombshell.
Is there any evidence that everybody thought that that was just...
Well, only Lord Walker himself said in Pirelli that it was a bombshell, and Lord Nichols, I think, said...
Where's the evidence that something that the Advocate General said is just patent nonsense?
I'm making that submission to you, my lord, and I will show you, because not only did Mr. Justice Park say what he said, but Lord Newburger said exactly the same thing in ACT Class 3, that it wasn't corporation tax.
If I, a multinational corporate, tottered round to my legal advisor on the
7th of
September 2020. On the 13th of September 2000, and said, "Oh, I've just seen this." People would have said, "Look, there's nothing in it. Absolutely nothing in it. It's just not even worth thinking about."
Well, the bombshell wasn't that sentence. The bombshell was, if you've had a surprise that there was an impact on UK tax at all. People have thought it was pretty well insulated before. That particular sentence would have been seen by expert advisors as an indication that maybe there's an argument here that if ACT is regarded by the ECJ as just corporation tax on profits, why could we argue that profits in the UK should be treated as the same as profits in Belgium, profits overseas? Could we argue that? Is that an arguable point? Interesting. Never been tried before, but we paid corporation tax overseas. That ought to be sufficient to frank and cancel an ACT charge in the UK.
But I mean, I don't. At the moment, I'm struggling to understand why, for example, what Mr. Justice Park said earlier actually is significant, given what the Advocate General said in 2000. Which
did you mean Mr. Justice Park, or did you mean Mr. Justice Richards? My lord.
I thought you were going to take us to
I am.
a case which was earlier, but
let me do it now. It's
Later.
sorry, later.
Keith, later.
Sorry, I've got got
yeah.
it the wrong way around. Sorry. Yeah, but
Well, my submission on this really is this. No one knowledgeable in this field would have regarded, we were arguing it under the Double Tax Treaty because they wanted a shot. But no one thought that ACT was just corporation tax on profits. It plainly wasn't. And yet that's how it was taken by the ECJ, admittedly initially by the Advocate General, and then repeated by the
But your well-advised tax, your expert tax lawyer, looking at the Advocate General, would at least, I think, assume that there is always the possibility that the ECJ will follow what the Advocate General has said, however stunning it might appear.
It's not so much stunning as wrong.
Well, right, wrong.
Wrong.
It might appear to be absolutely stone cold wrong, but we all know that the ECJ do, on occasion, like to follow what the Advocate General says.
Yes, well, you're, of course, my lady, you're right. You are right. But there are other reasons for saying why Hurst was, the Advocate General's decision in Hurst would not have led to the conclusion that the ACT charge itself was unlawful. But what I'm saying is, the reason given by the learned judge, was it a paragraph 181 or whatever it is, that there was a flaw in my argument, that reason was actually wrong. I don't think we went into this very much in the hearing. Let me take you to what Mr. Justice Park said. It was NEC tab 24. So authorities, volume 4.
It's actually volume 4.
Yes.
Volume 4. Sorry.
It is.
It's volume 4, tab 24. In my volume. Is it your volume? No, it's hardly been printed. Mine is volume 4, but it's tab 24, page 1211. And if you look at the holding over the page at 490, held 1, the advanced corporation tax regime discriminated against companies in the claimant's position contrary to the non-discrimination provisions contained in a double taxation agreement. Under the terms of these articles, the correct comparator, a similar enterprise in the United Kingdom, was a UK subsidiary controlled by parent companies resident in the UK which paid dividends to its parents. The taxation and other requirements on a subsidiary with foreign parents were more burdensome than the comparator insofar as the subsidiary with foreign parents was not able to make a group income election in respect to the payment of dividends. Then, where a double taxation agreement was brought into force in domestic law pursuant to the provisions of Section 788, it did not mean that all the effects of the provisions in the agreement were automatically incorporated in domestic law. Most of the effects probably would be incorporated, but some would not be. That was a result of the use of the words insofar as they provide for on the opening of Section 7883. Giving a natural meaning to the words of 7883A, that provision did not include relief from advanced corporation tax. Although advanced corporation tax was a species of corporation tax, Section 7883A did not provide for relief in respect of all corporation tax, but only corporation tax in respect of income or chargeable gains. Advanced corporation tax was not such a species of corporation tax. And if one turns to the judgment of Mr. Justice Park, at page 1228 of the bundle, 506 internally, it's part of his paragraph 43. Top of the page, I've held that the paragraph of the non-discrimination article relied on by the claimants meant that a UK subsidiary of a parent company resident in the other contracting state ought to have been permitted to make a group income election so as not to be liable to pay ACT in consequence of paying dividends. I accept that in that respect the paragraph provided for relief from corporation tax. However, I do not accept that it provided for relief from corporation tax in respect of income or from corporation tax in respect of chargeable gains. In my opinion, ACT, advanced corporation tax, is a species of corporation tax, but it is a different species of corporation tax. It is not corporation tax in respect of income or chargeable gains. And then if one drops down to 45, he says, I will now seek to demonstrate that ACT, although designated as corporation tax by the legislation, cannot sensibly be regarded as corporation tax in respect of income or chargeable gains. The charging provisions became, on consolidation, Section 14(1) of the 1988 Act, subject to Section 247, where a company resident in the United Kingdom makes a qualifying distribution, it shall be liable to pay an amount of corporation tax, ACT, in accordance with subsection 3 below. And then if one turns over to 46, para 46, in this connection it's worth reflecting on how the draftsman has expressed Section 14(4) of the 1988 Act, especially the second part of it. And the Corporation Tax Act shall apply for the purposes of advanced corporation tax, whether or not they are for the time being applicable for the purpose of corporation tax other than advanced corporation tax. Those words prompt the question, what is this corporation tax other than advanced corporation tax? In my view, the answer can only be corporation tax on the company's profits. That is to say, corporation tax in respect of its income and its chargeable gains. It can't sensibly be said otherwise. But this went on through the courts. We lost everywhere. And we lost in the House of Lords. And who dealt with this in the House of Lords but other than Lord Newburgh? The one who, in the Hurst trial in Metallgesellschaft, has said about ACT as corporation tax. And that's behind tab 29. And if one goes to para 46, bundle page 1429. In other words, the 1988 Act, when dealing with the interrelationship of ACT and mainstream...
Sorry, I've missed where you are.
It's paragraph 46 on
46.
Bundle page 1429. My lord.
Sorry, no.
In other words, the 1988 Act, when dealing with the interrelationship of ACT and mainstream corporation tax, first makes it clear that there will be circumstances in which ACT will not, even indirectly, through set off against mainstream corporation tax, be connected with profits. And secondly, acknowledges that mainstream corporation tax is charged on profits, i.e. income and chargeable gains, whereas ACT is payable in respect of distributions.
I'm sorry, Mr. Rhodes, I think I must have misunderstood. I thought you were going to tell us that the reason the AG's opinion was regarded as wrong was because of this case of NEC, but this case of NEC comes later.
This case of NEC comes later, which confirms the general understanding that ACT was never a tax on profits. It was a tax payable in respect of dividend to fund the credit. That was always the understanding of what ACT was. That was the coherent system. So when the Advocate General, then followed by the Court of Justice, said it's merely corporation tax, that's a sort of, hang on, that can't sensibly be said. No advisor would have thought that.
But I thought we were shown that Mr. Justice Neuberger, at first instance in Hurst, had decided the wording of the question that was referred, and referred to ACT as corporation tax.
Correct, but he didn't, would have had no idea what significance was going to be attached to it. It's section 14.1 says it's corporation tax.
Well, exactly. So that's why, as Mr. Justice Richards says, section 14.1 itself says this is corporation tax.
That's right.
An amount of corporation tax.
Correct.
So I have not understood, I'm sorry, I'm being very slow. I've not understood why what Mr. Justice Richards says is wrong when he says it wasn't the CJEU who first said that ACT was corporation tax. Mr. Justice Neuberger said it, and it's in the Act.
Yeah, but it's what's meant by corporation tax. Our argument was, until the ECJ said that ACT was to be regarded just as corporation tax, not as a separate species, a tax on the dividend, not something to fund the credit. Until it said that, no one thought of ACT in those terms at all. It was only...
Wasn't that the argument? We were shown, I think, the plaintiff's written observations in Hurst, written by Mr. Barnes, I think. And didn't he say ACT is just corporation tax?
Yeah. Yes. He did.
That's what he thought it was.
Well, if he thought that was arguable, why wasn't it arguable? Given that it did win.
All I can say, there's a sore point in that, because I was actually...
You were in Methelgesellschaft?
No, I was in Hurst, but I was in another court when the observations were signed, so my name never went on it. So I got a free lunch from Slaughter and May as compensation. But
you must have seen his observations.
Yeah, I probably helped write them and all. Yes.
Yes.
Well, okay, you try anything, don't you?
But then, isn't that what the Supreme Court has told us we should be looking for?
Yes, but that was a real trial. Let me put it that way.
So
there
was a trial.
We're not AC. Hurst case itself was not a trial.
Hurst case was worth trying on. That's the point my lord is making.
No,
is that once you get to the stage of you're asking whether the claim is viable, you might think, well, it's a very long shot, but it's not going to get struck out, and it obviously didn't.
My lady, the Hurst claim was a million miles away from the FII claim. It was simply saying that you have ACT that is payable both by a foreign parented company and by a UK parented company. There's always a charge of ACT. So no one's trying to avoid paying.
It's a timing issue.
It's simply a timing issue.
9 months timing issue.
But in the course of arguing it, we were saying that the reason why the foreign company doesn't pay ACT is that ACT is corporation tax. It pays its own corporation tax. That's the way it was put. That wasn't a try on it wasn't the leap to the FII case by saying, hang on, the fact that foreign corporation tax is being paid exonerates the group from paying UK tax when income is received in the UK? That's a totally different question. But that question could only really be raised once we had this statement that ACT should be equated to corporation tax. It was a stepping stone, a very important stepping stone.
Well,
Phrasing.
Yes, I think you're going to have to take this more slowly. I'm so sorry. My understanding of the chronology is that in 1998, someone persuaded Mr. Justice Newberger to put in the reference a statement that ACT was corporation tax. In 1999, the plaintiff's written observations for the court said that ACT was corporation tax. In 2000, the Attorney General wrote an opinion saying that ACT was corporation tax. But nevertheless, it wasn't until later, when you saw the judgment, that you realised it was properly arguable that ACT was only corporation tax. Have I understood that?
Yes. That's right, because the context was totally different. It was when you're looking at the judgment, you can say, yes, that's right, it's basically avoir fiscal, Hurst. We all know that. Mr. Gammy and other people thought Hurst was going to succeed. We all thought Hurst was going to succeed. It's only when we pored over the runes of the actual judgment that this point arose. We thought, hang on a second, hang on. Does this mean that we could argue that it's to be equated with foreign corporation tax that has been paid by our subsidiaries? Because if it does, then we've got the legs of an argument that FII, the franked investment income treatment, should follow. Tax has been paid, corporation tax has been paid, foreign corporation tax is equated with ACT, so it's as if the subsidiary has paid ACT. It was only at that point, which is why, no, I'm not giving evidence. Chronologically, yes you are. No. You may wonder whether post hoc is propter hoc. The fact of the matter is that these claims were started in 2002.
Yes, I can see entirely that if you've put a proposition and the Attorney General has accepted it, you might want to wait and see whether the court accepts it before you act on it. Because we all know that although the court very often follows the Attorney General's opinion, it's not obliged to and it doesn't always.
Yes.
So it makes sense to wait till you've got the judgment of the court before taking decisions on the basis of it.
Yes.
That's not a question, it's not the exam question on the paper that the Supreme Court has set. The exam question is, when is there a reasonable possibility? And it's not obvious to me at the moment why, as my lord said, that's not triggered at least by the Attorney General having said something.
Well, of course I see the force in what your lordship is saying. What I would urge you is to see the force in what I'm arguing to the contrary.
Yes. Well, I'm giving you an opportunity. I know you've argued it, but to try and dispel the mists which are clouding my mind.
Yes. But it's very difficult. You put yourself in the position of the advisor of a multinational, the hypothetical, well-qualified, knowledgeable advisor of a multinational, looking at the Hearst decision saying, okay, that was predicted, but hang on a second, the language used, that could be useful. Can that open up something else? Maybe yes, maybe no. Then came Lentz and Mannanen and made the job very easy. I mean,
but you accept that the judgment in Hurst was enough to
Yes.
start time running?
Yes.
Yes.
Yes. I mean, and really we are, it's such a shame there's just a few months between us, if I can put it that way.
That's often the case with limitation periods. If you're the wrong side, even by a day.
Yes, but if we're the right side, my lord, anyway, I've made my point. Yes. Unless there's anything I can say, can I, even though this is not the most popular time to rise, but he has an extra 20 minutes thanks to my learned friends going on. Are you happy to? I'm very happy to. Unless I can assist further.
Thank you.
Yes, of course.
Mr. Browning.
Would you just give me one moment to organise my station? what I was proposing to do was to address the court in some more detail on each of the 4 grounds of appeal which HMRC has before this court, and then to pick up and deal with some of the more detailed points on FCE's cross-appeal, which Friends has just been canvassing with the court. Before I do that, a lot of the general points have already been covered by Mr. I'm not going to repeat all of that, but may I please just emphasise one, which is the nature of the breach of EU law, and particularly the novel nature of these claims. And just to give the court two references, that was recognised by the Supreme Court itself, paragraph 78 of FI Supreme Court 2, where the court noted that the claims had been at the frontier of legal developments. And that's for a number of reasons, but one of the reasons that is particularly important in the context of the issues relating to limitation, in the context of the debate that needs to be had before this court, is that these claims sought to establish an obligation on the UK to grant relief for tax imposed by another member state. The claims were seeking to address obstacles to free movement arising from taxation by 2 states, so in international double taxation. And what I'll seek to demonstrate when we go through some of the detail of the underlying material is that prior to these claims, successful challenges to national tax measures based on EU law, they had been concerned with higher discriminatory tax burdens imposed by a single state, or other burdensome provisions imposed by a single state, not with the sort of 2-state situation with which these claims are concerned. And that's a point which the judge rightly identified, and this is in Mr. Justice Richard's judgment, paragraphs 83 and 97. Could I please ask the court to turn those up at the back of the core bundle? Behind tab 40 is the amended judgment. And I didn't detect any challenge to these paragraphs in Mr. Hewitt's submissions, either in writing or orally, but they're important because they have a real impact on the consensus which Mr. Gammy identified.
Sorry, paragraphs.
83 is the first one and 97 is the other. It's 83 is at the bottom of page 511. Could I please just ask the court to read paragraph 83? It's particularly the sentences starting, these were not just challenges, and rather the challenges struck right at the heart.
Matters which hitherto had been dealt with by double taxation treaties on a treaty-by-treaty basis, presumably.
Yes, correct. And he goes on to develop that. I think I just need paragraph 97, which is at the bottom of 515. And you'll recall that the judges defined those terms, D5 challenge and ACT challenge. And he's dealing here with the sorts of questions that those challenges raised. And he explains in turn what each of those challenges sought to establish. So for D5, this is that the UK should refrain altogether from taxing dividends received from non-UK EU resident subsidiaries, even though the UK hadn't collected any tax on the profits out of which the dividends were paid. And then for ACT, seeking to establish that the UK should treat EU dividends as FII, consequent reduction in the amount of ACT collected. And again, that's even though no UK tax was payable on the profits out of which the EU dividends were paid and no ACT paid. the consequence is, different ways of putting it, but either the UK is being asked to give up its taxing rights in respect of this foreign income, or the UK is being required as a matter of EU law to give credit for the overseas taxation. And as we'll see when we look at some of what Mr. Gammy had to say, that's a very important point on the background to this. It's the enormity, if you like, of the propositions that were being sought to be established, or at least of their consequences. I wasn't proposing at this stage to set out any sort of schematic of why we say the judge got it right. The court will have gathered from Mr. Anson's submissions, our position is the judge was faced with an evaluative question. That's what the Supreme Court had left him. It's for the revenue to upset that evaluation. I do also say, though, that even if this court were engaged in simply asking, is the judge right or wrong, he wasn't just entitled to find as he did, he was absolutely correct to find as he did. And so, time permitting, I will just at the end draw the threads together and explain on the basis of the evidence why he wasn't just entitled to his conclusion, but why he was absolutely correct so to find. But I hope it assists if I focus in turn on the revenue's 4 grounds of appeal, because my starting was one or more of those has to get home for anything to be done about the judge's judgment on the main issue. So could I start, please, with ground 1? And the court will recall that's a series of complaints about the test that the judge applied. And in writing, in Malone Friend's skeleton, in his appeal skeleton, paragraphs 41 to 48, and it said, for example, that there isn't a detailed analysis of the worthwhile claim concept. There's a point about the language of would and could. There's a complaint about the language of constructive discovery, and there's a complaint that it said the judge failed to give proper weight to the burden of proof. Not all of those were canvassed in the oral submissions. There were some differences of emphasis, but I'm very happy just to deal with each of those in turn. But before I get into the detail of our response to those complaints, please may I make two key points by way of preface. The first is that the judge correctly set out the relevant principles in paragraph 21 of his judgment. And even the revenue accepts, and this is paragraph 48 of the revenue's appeal skeleton, that at times the judge set out the correct test. And nothing that's been said, either orally in writing in my submission, even approaches the identification of a misdirection of law on the judge's part. There is no reason at all to think that, having correctly stated the test, that the judge then applied some different test to the one that he's identified. The revenue in my submission isn't recognising properly the evaluative nature of the test the judge had to apply. Rather, certainly the way the complaints are put in writing, what this court's being invited to do is to subject the judgment to exactly the sort of narrow textual analysis that this court has often deprecated, and I'm sure I don't need to ask the court to go back, for example, to Volpe and Volpe. It's in the authorities, page 1680. I'm sure the court doesn't need me to remind it of the guidance of how to deal with challenges of this nature. The second point, by way of preface, is that the revenue's ground 1 in my submission can't stand alone. On the findings that the judge made as to the consensus, even if there were some merit in one or more of the points, it remains the case that there's no way that the claim could have been discoverable through the exercise of reasonable diligence before June 97, which is the date that the revenue would need. So please can I deal with the 4 complaints. The first is that there wasn't a detailed analysis of the meaning of worthwhile claim. And then it said that the conclusions on worthwhile claim are inconsistent with what the Supreme Court has said. I say there's nothing in those complaints. We know, as I've said, that the judge correctly identified the test. And that's paragraph 21 of the judgment. And that's in 496 in the core bundle, where he sets out his summary of what he's drawing from Supreme Court 2. And he sets out, in particular, the two ways in which the test is put by the Supreme Court in paragraph 193. The preliminaries test and the worthwhile claim test. And he tells us in terms, paragraph 25, halfway down page 498, that he's not going to give either test any greater significance than the other. And as it happens, one sees that in action. In paragraphs 139 and 140, where the preliminaries test is applied on the basis that worthwhile claim isn't giving any sort of higher standard. And the judge is also absolutely clear, and I think we touched on these paragraphs with my learned friend this morning, 21 Roman 5, page 497, the worthwhile claim test isn't about when the claimants could have expected their pleaded claims would succeed, nor is it about a complex evaluation of chances of success.
Nothing wrong with either of those, you say?
Correct. And he's also clear, Roman 6, this is about when the mistake could, with reasonable diligence, have been discovered, not whether it should have been. That all shows the basis upon which the judge was approaching the worthwhile claim test. And so that the complaint that there isn't detailed analysis of what worthwhile claim meant, in my submission, is just wrong. And it's also wrong to say that the judge's analysis wasn't consistent with FII Supreme Court 2. The judge was careful to direct himself in accordance with Supreme Court 2. One of the key errors in relation to this complaint on the revenues part, certainly the way it was put in writing, is in Malone Friend's skeleton, paragraph 42 sub 2. Although I don't think I'm being unfair in saying I think there was a degree of rowing back from the starkness of this point in the oral submissions, but in writing it was said, if it was worth taking advice about the claim was worth investigating. That, in my submission, is a misunderstanding of what the Supreme Court found and a misunderstanding of the preliminaries test. What one has to bear in mind is that the Supreme Court has told us, and the Court's seen in these paragraphs, that in terms of the standard, where one needs to get to is that there is a real possibility that such a mistake has been made. That was paragraph 178 of the Supreme Court. And paragraph 255 is the approval of what Lord Walker had said about there being good grounds for supposing that there was a valid claim. And I don't want to labour the point, but all of this also has to be seen in the context of the nature of the mistake that we're talking about. It is a mistake about the law. Necessarily, one is only going to be able to even begin to uncover that such a mistake has been made with the benefit of some form of specialist advice. So it's wrong to say that if it was worth taking advice, the claim was worth investigating. That just doesn't follow at all. What both the preliminaries test and the worthwhile claim test are doing, they're illustrating the strength of the belief that has to be held. And they have to be looked at in the context of the Supreme Court's other observations. We're looking for whether the basis of this payment is legally questionable. And so what the judge was testing, quite rightly, was both the question of when a well-advised multinational could have had sufficient confidence to embark on the preliminaries of it, to the issue of a claim, also on the worthwhile claim question. And our position is simply this, that he was absolutely entitled, indeed correct, to find that that threshold can't have been reached at a time when there's a professional consensus that a claim of this nature is not viable. That question needs to be looked at on a factual, real-world basis. The question is not, sitting here now in some abstract sense, could a claimant have been in a position to take advice, or might somebody back in 1996 have been capable of giving advice that there was something to look at in terms of the compatibility of a domestic tax provision with EU law?
Well, you've got to ask a rather sort of hypothetically slightly artificial question, which is you've got to postulate that somebody comes to a tax advisor and says, if I run it's just occurred to me, I might run an argument that I shouldn't have to pay this tax because of EU law. What do you think?
Yeah, and you can see, and
nobody did, of course. At least as far as we're aware, nobody did.
Nobody did, and there's a rather lengthy note, which I fear I was responsible for at the trial, which has made it into the supplementary bundle as to what people actually thought at the time. And that note, it's the claimant's note on factual matters. I'm not going to ask the court to read it. But it's tab 8 of the supplementary bundle. That sets out the evidence as to what advice had actually been received. And the most detailed evidence that was available was in relation to BAT, who had taken advice of lots of different kinds to seek to deal with the problem that they had in relation to ACT. The point we made to the judge was none of that threw up any hint that there might be something to be said under the treaty. It's a little bit like the discussion that was being had in relation to the Ruding report an hour or so ago. What, of course, the judge did, and you can see this in paragraph 29, Roman 1 of his judgment, and this is a function of the assumption that has to be made that the claimant wants to discover the mistake. He looks, 29.1, what steps would be taken to seek to discover whether the provisions in question are compatible with the treaty. And he asks, okay, well, to what extent that would involve taking advice. And then in his 55, he notes, and this follows from this is quite a strict application of what was said in Paragon Finance and Thackeray and Law Society and Sefton. Second sentence, that the well-advised multinational is assumed to want to discover whether any mistake has been made. And he says, accordingly, it's because of that assumption, you have to assume, as my lady rightly says, you have to assume that there is this asking for advice on whether the relevant law was compatible with EU law. So, and that's consistent, as it happens, with the notion of a well-advised multinational, because if you're hypothesizing a well-advised multinational, at the very least they have access to good legal advice. But as I said earlier, in a case like this, a claimant is going to need advice in order to work out whether there is some basis for arguing that it has made a mistake of law. And then if the outcome of that exercise is in the negative, no claimant is going to embark on the preliminaries to litigation. It can't be said that there is the discovery of a worthwhile claim. Now, my friend mentioned a couple of times in his submissions AB and the Ministry of Defence. I do just want to explain why it is that AB doesn't help the revenue in this exercise, but looking at the time, it may be better if I do that at 10:30 tomorrow.
Right, is that a convenient moment?
It is for me, Molly, if it's convenient for the court.
Fine. Well, we'll resume at 10:30, and thank you very much.
I'm grateful.
What